call the Honourable Amy Adams.
Mr Chair, thank you. I do want to take a call earlier in this debate, and I'll take the opportunity to respond to the points Mr Parker raised, and I also just want to touch on what I also understood to be the SOPs in front of the House, and given that the House has granted a little bit of leeway to Mr Parker to talk about them, I'm sure it will be equally generous in allowing me a little bit of leeway to respond to it. Mr Chair, may I begin just, of course, with the very overarching comment about the effect and impact of the bill, I think, is one that has, as far as I know, broad support in the House as to its aims, which are effectively to ensure that our vulnerable witnesses, particularly child witnesses, are far better protected in the ways in which they can give evidence, and so that when prior video evidence is taken, particularly in sexual violence and involving vulnerable complainants, that evidence is very carefully handled, and of course the changes that Mr Parker made reference to in terms of prior consistent statements. If I can just firstly address the issues that Mr Parker raised around clause 26 and the impact of the changes there, I can confirm for Mr Parker that the changes in this solely pick up the Law Commission recommendations, which is really just to move what was in clause 35 of the Evidence Act into clause 90 as it's being its better place. There's a slight amendment in my SOP simply because the drafting left out a single word, but a reasonably important one, which is admissibility. And so we have just made sure that the bill, as you have it in front of you with the addition of the government SOP, simply replaces the original wording of clause 35.3 into the new location as reflected by the Law Commission. So I can assure Mr Parker that it is both simply giving effect to the Law Commission recommendation, that it doesn't change the operation and the practice that is well understood in that respect with what was section 35.3 and will now be in section 90. I am just going to briefly again touch on what I understood to be the SOPs from Jan Logie, and let's work with the benefit of doubt for a moment, and the House can ignore...
I wonder if we could have clarification, because I've just been approached by the Greens whip to say that their understanding is that those supplementary order papers that I was addressing were in fact tabled and are live. So if we could have some clarification of that, Mr Chair. I'm sorry to interrupt the Minister, but the Minister's answers too.
Yes, so to clarify that, supplementary order paper number 195 in the name of Jan Logie and 194 in her name are live.
Thank you, Mr Chairman. So it's nice to know that Mr Parker and I both were operating off the same information, and that it was in fact correct, which is always an added bonus. So we have, it's not always the case, but we'll take it. So we have the two SOPs from Ms Logie, and I certainly want to support the intention that I know she's trying to deliver in the space, which is better protection for vulnerable witnesses. And while the government won't be supporting the SOPs, I do want to pass on my assurance to the House that we are absolutely interested in continuing to work on further ways that we can support victims of particularly sexual and family violence in the manner in which they not only give their evidence and the use of alternative means, but actually a far wider range of changes than that. Mr Parker made comment in his contribution about the fact that actually, while there's a lot of ability for us to make improvements in the space, it is in fact an incredibly complex area. My view in getting this legislation up in this time frame was that the changes we had encompassed here were clear, they were straightforward, they were well supported, and the sooner I could give effect to them, the better. The changes that we're working on around the Law Commission's piece of work around sexual violence, family violence, the way the court responds, are extensive. They combine a range of changes from the minor and simple through to the quite considerable reform of how we think about our system of laws. I think we should be open for that discussion. I think it's a big discussion to have, but I think it is one that we take time to get right. And while child witnesses and sexual violence and family violence complainants and victims have some matters in common, they are actually quite different vulnerabilities that you're dealing with, and I think the solutions need to be thought through carefully. Now, obviously, in some cases, a witness will be both a child witness and also a victim of sexual violence, and of course the main thing is that the most comprehensive level of protection should apply in that case. But where we're dealing with sexual violence victims who are not children, While I absolutely have a piece of work in front of me which is comprehensive in looking at these issues, I don't think it is as simple as saying, well, if you give your evidence through CCTV, we can consider the support of sexual violence victims appropriately dealt with. But I am very interested in working not only with Ms Logie, but with members around the House who I know have an interest in improving this area of work. If I can talk then to Ms Logie's other SOP, which the government also won't be supporting, SOP 104, that's seeking to amend Section 85 of the Evidence Act to explicitly provide that a judge may disallow intimidating questions. The reason, again, we're not proposing to support the SOP in this form is simply that I'm satisfied that for current purposes, the existing ability of the judge to order the questions be ruled out of order because they are unfair or improper gives the judiciary a very wide range of redress in the case of intimidating questions. Again, certainly the whole conduct of our courtrooms, the conduct of defence counsel, the conduct of sometimes prosecuting counsel, more usually defence counsel, and the questioning of witnesses is part of this wider piece of work that we want to be considering. Can I just make the point too, really referring back to the earlier SOP, that while this bill sets up a clear presumption in favour of the use of alternative ways of giving evidence, there is still an absolute, Mr Chairman, still an absolute ability for the judge in any case to make that determination. So it shouldn't be mistaken that sexual violence victims don't have the ability to give evidence through alternative means. They absolutely do. What we've done in this bill is create a rebuttable presumption that that should always be the case for child witnesses, and I would expect that judges do use that with considerable care when it's appropriate for sexual violence victims now. But if I can simply reiterate my support to Ms Logie and the House to continue to work on how the whole system of prosecuting sexual and family violence is better dealt with, I will absolutely do that. However, I'm not convinced that these SOPs pulled out as individual little aspects of that piece of work are best progressed in this form. I note the Select Committee considered them and rejected them, and I share their view, but the work is an important one which will continue through another channel.
Stuart Nash.
Thank you, Mr Chair.